Hello, and welcome to another episode of Trust and Trade, a podcast produced by the Antitrust Law section of the American Bar Association. Trust and Trade is a podcast for seasoned practitioners interested in deep dives into the areas of competition, consumer protection, and privacy law, and casual listeners who want to better understand some of the headline-grabbing issues in these fields. Each episode is presented on one of the specialty committees within the section. This episode is produced and co-hosted by the Trade, Sports, and Professional Associations Committee of the Antitrust Law section. Today's episode is on Michael Jordan versus NASCAR. Michael Jordan, considered by many to be the greatest basketball player of all time. In many ways, Michael Jordan the individual has transcended Michael Jordan the player, launching an iconic shoe line, becoming a global ambassador for his sport, stepping into the role of management for the Charlotte franchise, appearing regularly in semi-pro golf, and most recently, in a move fulfilling the dreams of any native North Carolinian, joining the world of competitive auto racing. Jordan teamed up with retired NASCAR legend and three-time Daytona 500 winner Denny Hamlin to field a competitive car racing team, 2311. The Jordan's team and the second team, Bob Jenkins Front Row, and NASCAR have been locked in a heated antitrust lawsuit over the charter system at the heart of the NASCAR Cup Series since October 2024, with the case set to go to trial on December 1st, 2025. So why exactly is Michael Jordan suing NASCAR? And how will this end? Here to explain this fascinating case to us are our guests for this episode. Professor Jodi Balsam is a professor of law at Brooklyn Law School. Professor Balsam has served as an arbitrator for the NCAA on complex infractions cases, and now serves as a neutral for Fair Sports, which hears commercial cases involving college athlete name, image, and likeness issues. Before joining academia, Professor Balsam was the National Football League's counsel for operations and litigation. And prior to that, she was a litigator at the law firm Simpson, Thatcher, and Bartlett. Welcome, Professor Balsam.
Nice to be here.
Sathya Gosselin is a partner at Hausfeld in Washington, D.C., where he frequently litigates sports and antitrust cases, among them O'Bannon versus NCAA and In Re Sunday Ticket NFL antitrust litigation. He's also the chair of the Trade, Sports, and Professional Associations Committee of the Antitrust Law section, which is co-sponsoring this episode of Trust and Trade. Welcome, Sathya.
Thanks for having me.
Jodi, let's start with you. What is this case about?
Well, what it's not about, I should say, is the business practices of a traditional sports league. One thing that observers of this case need to understand is that NASCAR is a solely owned private corporation by a family known as the France family, who have created a structure for hosting stock car races. The teams that compete in those races are in a contractual relationship with the NASCAR entity to race in those in a circuit known as the Cup Series for increasing media coverage and revenue. But just to be clear, NASCAR is not an association in the sense we typically understand it in sports. As a private company owned by the France family, there are no public shareholders. There are no external ownership groups involved. The teams that race in NASCAR races are not owners of that entity. They depend on NASCAR extending them an opportunity to race, either through a recent development known as the charter system or through having accumulated points in other levels of competition. And as a single entity private company, NASCAR would generally be considered free to make independent decisions about who is eligible to enter its races, the specifications for race vehicles, how the races are conducted. And it has significant, although not unlimited, freedom to enter into exclusive contracts with vendors and suppliers and to refuse to deal with companies it doesn't want to do business with, right? It may choose its own business partners. However, they've now, over the course of 80 years of NASCAR's existence, created an entertainment product that has evolved over time, responded to consumer interests, but also extended its business relationships in a number of directions that have made it very difficult for any other premier stock car racing circuit to emerge and provide an alternative outlet for these racing teams, Michael Jordan's team, Front Row team, to find a way to compete. And that's the issue in this lawsuit, how NASCAR's success, one that we should applaud, has perhaps, in the allegations in this complaint, been abused in raising barriers to entry for any other stock car racing circuit to emerge, and then extracted monopsony profits in its dealings with the two race car teams that are protesting the latest iteration of its charter arrangement.
Jodi, when you were describing how NASCAR is set up, it called to mind for me the McMahon family and professional wrestling, in that for a while you had various regional professional wrestling organizations, but you had this one family controlled business that eventually just became the only place where professional wrestlers could earn their living, even if that is a publicly traded company, not an entirely privately family held, but it is controlled by one single family.
Exactly. And that's a very fair analogy. And what this case examines are the ways in which NASCAR has built on its legitimate success to inhibit entry from other potential stock car racing circuits.
Jodi, what is the charter system? Can you explain that to us?
Sure. So over the course of the first 5-6 decades of NASCAR, the teams that competed had no guarantees that they would be offered a slot in the race. They had no guarantees they would be offered a share in the revenue. As NASCAR became increasingly prosperous, the teams formed a collective called the Race Team Alliance to collectively demand that NASCAR negotiate a fairer deal with more predictability and a guaranteed share in their revenue, mostly derived from the sale of media rights. The charter system was introduced in 2016. If you purchased a charter, actually, originally the charters were awarded without any fee attached to them. If you were the recipient of a charter, it guaranteed race entries and revenue sharing for those teams. It aimed to stabilize team finances, encourage long-term investment. Initially, 15 teams were awarded a total of 36 charters. So teams were awarded more than one charter so that they could offer to race more than one car. And as I said, these charters initially were offered at no cost to teams that had demonstrated a consistent participation in the Cup Series. And it was a 9-year term that expired at the end of 2024.
And if we could go into the history of the charters, which I find fascinating, because I think when we first talked about it, you pointed out that it was almost a cartel on the ownership side, as we struggled to figure out who was the quote unquote good guy in this case. But it was cartel behavior on the ownership side that led to the creation of the charter system.
That's true. To counterbalance NASCAR's clear monopsony power in offering opportunity for premier stock car teams to race in a circuit like NASCAR's, they formed this collective, arguably a cartel, and came to NASCAR to negotiate collectively to leverage their unity in that setting.
And just so listeners can understand kind of the economics at play and what was driving the owners a little bit here, running a competitive car team is enormously expensive. I mean, there's a lot of people you have to have on staff. There's a lot of equipment you have to purchase. And the Cup Series, I think every race, I don't know if this has always been the case, they have 40 slots. And so if you are the car owner and you're investing in this car company, before the charter system, you don't know that you are necessarily going to be able to put your car in every race. You can't go to sponsors and sell advertising on your car if it's not going to be in every race. And if you just had to get out of it, I think before the charter system, they were just selling they were selling for parts. I mean, there was nothing that they had, there was no investment or no return on investment. And the charter system, it struck me as a little bit like the New York taxi cab medallions that, Uber and other rideshare companies have upended. But the value of the medallion itself, it struck me as like the value of having a charter meant you are guaranteed entry into this premier series, which you can then use for long-term investment and sponsorship.
Exactly. And the long term, when the charters were first initiated, was a 9-year term. Teams were allowed to sell or lease their charters, and to not to find a point on the value of having this predictability, they created a market for the charters. The asset is now valued at about $40 million in a free market that has emerged around the charters. But the charters did expire, and in negotiating the new charters, the NASCAR side took a harder stance. They had just entered a major new, richer media deal. And they were willing to give the race teams their share, but they had incorporated a host of new demands, which only 13 of the 15 race teams agreed to sign on to. The two that didn't, Michael Jordan's team and Front Row, protested that the deals need to be a little bit richer for the charters. They only gave up around 20% of collective of the aggregated revenue to the teams. Compare, say, what athletes in some of the major league sports in the U.S. get through their salary caps. It's closer to, say, 50%. And a number of teams opposed the shortening of the term from 9 to 7 years, caps on each team at 3 charters, with some of the 4 charter teams grandfathered. Even though minimum annual payouts were raised, they felt they deserved more of a larger share of the pie. And they also objected to the next-gen car program, which I can explain in a little more detail. But that's part of actually the antitrust complaint. But the negotiations came to a head with the Jordan team and Front Row refusing to participate in the charters as written, 13 teams agreeing to do so, and this antitrust suit being launched.
So the issue here in this case is the terms of this 2025 renewal of the charter agreement that the teams entered into some 9 years prior to that. What are the antitrust issues involved here?
Some of those issues have already been resolved through summary judgment. What 2311 and Front Row Sports allege is that there's this input market for premier stock car racing teams in the U.S., a narrow market defined so that NASCAR is essentially the only competitor and has complete monopsony power. And then, of course, the second issue in this Section 2 monopolization or monopsonization claim is, has NASCAR abused that power? And that's actually all that's left to be tried on December 1st, because the district court issued summary judgment on market definition in favor of NASCAR. So NASCAR is now facing a fairly uphill battle to argue in front of a jury that despite being a declared monopsonist, operating in this very narrow market for premier stock car racing, its activities have not created any barriers to entry or willfully abused that monopoly power. So in early November, a significant aspect of the case was already decided in favor of the 2 teams who have brought the Section 2 monopolization claims. They won a summary judgment motion on market definition, where the court agreed with their market definition that was fairly narrowly drawn for premier stock car racing teams in the United States. In that market, NASCAR is the only competitor, and according to the court, is a monopsonist. And the question remains for the jury to decide as of December 1st, have they engaged in willful acquisition of that monopoly power? Have they abused it? Have they raised barriers to entry? And the allegations of the complaint include a number of ways in which the 2 plaintiff teams have a pretty strong argument. So first, there are some fairly standard exclusivity provisions that would be deemed quite ordinary and routine in other sports. For example, teams that race in the Cup Series, NASCAR's premier racing circuit, cannot compete in other racing circuits. Fair enough. The Dallas Cowboys can't compete in any other league than the NFL. NASCAR has also, according to the complaint, predatorily acquired other stock car racing series that would have been competitors to its own, and once acquired those series, demoted them so that there are fewer options for the premier racing teams to compete. They also acquired International Speedway Corp., which had owned 13 of the country's premier racetracks, including the famous Daytona and Talladega. So they now not only own a number of the premier racetracks, but those remaining independent racetracks they require to agree not to host other premier stock car racing events as a condition of being awarded a Cup Series event. In total, they have either ownership or exclusive control for the purpose of premier stock car racing of about half of the eligible tracks in the country. And finally, I mentioned this earlier, the next gen car program. So that requires teams to race cars that comply with technical specs and purchase parts from single source suppliers. Not so different than what we see in other sports, for example, golf, where players have to comply, their equipment has to comply with standardized specifications for golf equipment. You can't use a putter of a certain length. It happens across many sports, including tennis or even football. But the Next Gen Car program does not give purchasing freedom to the teams. They must use the single source suppliers designated by NASCAR. And Next Gen Car parts remain the property of NASCAR and cannot be used in other racing events. So as you mentioned, they spend tens of millions of dollars building these vehicles. Now they're required to do so with Next Gen Car parts, and they cannot repurpose the vehicles in any other stock car racing event.
Yeah, Sathya, I don't know whether you had the same reaction that I did, but as Jodi was describing the various issues in this case, it seemed like a Frankenstein of other antitrust cases from the past. I mean, the market definition reminded me of the super premium ice cream merger from a couple of decades ago. The acquisition of the tracks by the car racing company reminded me of Ticketmaster Live Nation, where the ticketing company is accused of having monopoly power over the venues. And the next gen issue seems like, classic aftermarket lock-in, Kodak style. So I don't know if the two of you have thoughts about the merits of these arguments, or Sathya, what do you think about some of the issues in this case?
Sure. Let me first offer a few observations, I think, in line with your own, and then talk a little bit about what I've seen from the publicly available filings in this case and where some of the direction of this trial might go come December, understanding that it's public. The parties are in mediation and there's the potential for settlement here. I think the first aspect that really stands out is a point that Jodi made, right? That this is the unusual instance of a major team sport association in the United States in which the league is an entirely different entity from the team owners, right? This is a family-run enterprise, albeit to the tune of billions of dollars, with the teams on the other side complaining about the conditions of their engagement, right? And the story that the plaintiffs are telling here through their filings and the evidence that they've amassed at summary judgment is one, as you note, that looks a lot like various forms of exclusionary conduct that you don't often see litigated between team owners and leagues, right? I think that there's a fairly compelling case for the willful acquisition or maintenance of monopoly power through exclusionary conduct here, whether it's the next gen restrictions that Jodi mentioned, right? The teams are forced into a position where they don't even own their cars, so obviously can't use those cars at anyone else's races. The venues themselves are principally owned by NASCAR, and so there isn't the opportunity to put on other races or to form a competing premier stock car racing event or association. And it goes on, right? The charter non-competes, the various terms, even the salacious allegations about the NASCAR insisting the team sign the new charter agreements within an hour of receiving them in the heat of negotiations, things like that. That all seems to me to have a fair amount of appeal for a jury, particularly in North Carolina. We haven't talked much about Michael Jordan's connection to all of this. And so this is an open question, but I tend to think highly of the plaintiff's liability story and evidence from what I've seen. I also think there are some sympathetic arguments from NASCAR when it comes to remedies, right? That the plaintiffs here are seeking mandatory injunction, and Jodi can tell us a little more about the trips up to the Fourth Circuit and their attempts at a preliminary injunction. But fundamentally, they are looking for a mandatory injunction that enables them to contract with NASCAR on their preferred terms, which is unusual, to put it mildly. I'll stop there as we start to debate some of this.
Jodi, how would you respond?
So it's probably worth rehearsing what actually happened in the preliminary injunction motions, because a lot of the points that were just made were informed how the courts ruled there. Initially, the case was heard by a judge who rejected the first attempt by the two teams to obtain preliminary injunctive relief that essentially would compel NASCAR to do business with them on their preferred terms during the pendency of the lawsuit. And the court essentially found that that was not an appropriate basis for preliminary injunction relief, that the irreparable harm could be ameliorated by the teams participating in the races through the slots available to open teams, right? So every NASCAR race has 40 slots. There were 36 charters. There's always 4 slots available to be able to enter without having joined the charter relationship. And that option was open to the 2311 and Front Row sports teams. Later on in the lawsuit, the judge stepped down and a new judge was assigned to the case. The new judge granted a second attempt at a preliminary injunction, but the Fourth Circuit vacated it, finding that the two teams were unlikely to succeed on the merits of their antitrust claims. So the reason for the injunction being denied shifted from the absence of irreparable harm to a Fourth Circuit view that the underlying antitrust claims lacked merit. And they said some interesting things that might indicate what they would say if there were a liability verdict that condemned NASCAR's behavior, which was then appealed back up to the Fourth Circuit. They said that they found no support for the proposition that a business entity violates the antitrust laws by requiring a prospective participant to give a release for past conduct as a condition of doing business, or to be bound by something that you're simultaneously contending violates the antitrust laws. Summed it up in this Fourth Circuit reversal of the preliminary injunctive relief, antitrust law is not a negotiating tool for a plaintiff seeking better contract terms. So to Sathya's point, this does strike one as an unlikely antitrust success at the end of the day after appeal, even if it might gain a jury's sympathy.
I tend to think that the plaintiff's liability case here turns on more than just the hard-nosed negotiating of the charter agreements that NASCAR portrays it as, right? If it were really just boiling down to differences of opinion as to the appropriate terms under which the charters would be granted, I think that would be one antitrust case. But from what I'm reading from the plaintiffs, this is really a soup, and not your point, or broth, right, of a great deal of exclusionary conduct that has resulted in NASCAR being the only place to engage in premier stock car racing. It's been true for decades, and it includes an acquisition strategy, it includes an exclusivity strategy, it includes various non-competes, and it includes some daring use of intellectual property restrictions. And when you take that together, that to me seems fairly compelling. I think we do agree on some of the potential challenges surrounding injunctive relief and remedies. I also want to invite Jodi, you and I, to talk a little bit about some of the quirks and turns in the course of the litigation, some of the concessions made by the parties and ways in which counterclaims have hurt their litigation strategy. Do you want to talk a little bit about that, or would you like me to?
Before Jodi responds, if I can just jump in with one thing, Sathya, to your point, and for our listeners, I was reading some of the statements by some of the other owners that came up. I forget, as part of this litigation, some of the other owners who signed their new charter agreement. And you have, Joe Gibbs on one, and this is not, some poor blue collar worker. You have Joey Logano, who's with another team. And their statements were basically, yes, we signed. What choice did we have? All right, Jodi, let me turn it to you.
One of the interesting factual dimensions is how the casual observer might think that there are lots of other ways to go about earning a living as a race car driver if you can't do business with NASCAR. But in fact, the different vehicles and different sort of structures of the competing circuits basically mean that it's entirely different sports, right? A NASCAR team a stock car racing team can't switch to Formula One, an argument that was made by NASCAR in contesting market definition. They can't switch to IndyCar. It's quite specific. I mean, it's almost as if you tell a tennis player, well, if you don't like the way the ATP runs the tour, go play golf. The other sort of interesting feature of the market definition argument was that NASCAR earlier in the suit brought counterclaims. Remember, we talked earlier about how the race car teams had collectively attempted to use their group leverage to negotiate better terms. And ultimately, while 13 took the take it or leave it deal, two of them, Front Row and the Michael Jordan team, essentially worked in tandem to try to convince NASCAR to meet their demands. NASCAR, in its counterclaims, depicted that as a Section 1 conspiracy between the two teams to pressure NASCAR into accepting their preferred charter terms, essentially acting as an illegal cartel to impose their will on NASCAR. So this past October, the judge tossed that claim because it found that the joint negotiation tactic didn't cause any antitrust harm to NASCAR and didn't impede anybody's opportunity to negotiate individually. In the course of bringing those counterclaims, NASCAR argued necessarily for a fairly narrow market definition. In fact, for a market definition that closely tracked the affirmative claims brought by the two teams. And the judge, in granting summary judgment, held NASCAR to that position. Having defined nearly the same market as the teams in its own counterclaims, it was not allowed to contest that in the summary judgment motion by pushing for a broader market that encompassed other race series like IndyCar and Formula One. So it was somewhat hoisted by its own petard in taking an aggressive approach in its own counterclaims, and it might have been a safer pleading approach to simply move forward solely on the plaintiff's claims to be able to contest market definition more strenuously.
Anant, can I point out too what I think are at least three atmospheric aspects to this litigation as it hurtles towards trial? I'm not sure that I'm entirely right about these, but I've been thinking about three aspects in particular. The first being something that you made mention of earlier, which is there's a way in which this case could be construed as really a disagreement among billionaires, right? In a way that is potentially unsympathetic to jurors who are taking time out of their daily lives to really devote to what is presumably 2 to 4 week long trial, right? And then learning all about the sort of history of disputes and even how there wasn't much dispute among these parties until quite recently. NASCAR makes much in their summary judgment effort of how it is that these two teams acquiesced or even with sophisticated counsel, right, readily agreed to these terms until the most recent charter negotiations. The second piece to me goes something like this, and see if this resonates with either of you. It feels to me like this case has aspects of a more traditional lockout following a collective bargaining agreement expiration. That is, there is this dispute among stakeholders within a sport in the United States that here is not actually preventing the season from moving forward, but nevertheless is creating disruptions and is consuming a great deal of public attention, right? And stands to sort of materially change the way in which the sport is played and on what economic terms, so much so that we have other teams and drivers entering the fray in the form of amici to make sure that they are heard, particularly as any settlement might need to be negotiated. Those things in particular stand out for me. I had a third, but it escapes me. It'll come back as soon as I throw the mic to one of you.
So I agree. It does have parallels to traditional sports that are organized around member clubs who collectively own the league and their relationship with their athletes. But the teams here are not sort of analogs to athletes. They are independent businesses, as pointed out, each billionaires. They can't unionize. And by virtue of that, whatever agreement they reach with NASCAR is not entitled to any labor exemption under the antitrust laws. And I think it all does circle back to what will the remedy be and how will that remedy establish a level playing field competitively amongst the teams that didn't bring lawsuit against NASCAR.
It's interesting too, Jodi, your point about how under no circumstances can they enjoy some sort of antitrust immunity. They've been attempting to do that and successfully, I gather, to date in the form of antitrust releases as part of the charter agreements, which itself becomes one of the negotiation points and causes for the litigation, right?
And that is a page taken from the Major League's handbook. I'm aware that every transaction of any ownership interest in a club in any of the major leagues now comes with the requirement that you sign a release of all antitrust claims. How enforceable that release is, unclear, but it certainly is an acknowledgement of the power and the leverage of the antitrust threat. When you are in a position of negotiating with a dominant existing sports league that monopolizes the highest level of competition in your sport.
Well, just one last point about that, you noting, however enforceable those terms might be. Another unusual aspect of this case to me is the very highest levels, right, of a very successful sports league in the United States airing its dirty laundry in the form of public litigation here, which is quite unusual. And so it strikes me that in other leagues, right, you might just see less willingness to test, for example, the boundaries of those antitrust releases in public litigation, right, hurtling towards a trial, ultimately determined by a jury.
In the other leagues, they also have mandatory arbitration of these sort of internal disputes, although that has been sidestepped in some of the more, legacy antitrust cases. But I'm curious, and I don't know the answer to this, maybe you do, Sathya, whether there was an arbitration provision in the charter.
My understanding from reading a great deal of documents, but certainly not everything that's been filed in the case publicly, is that because they were operating out of time, right, from an existing charter agreement, any arbitration provision that might have been in the previous, now then expired, right, charter agreement wouldn't have adhered. That was the best that I could surmise.
So I'd like to get your thoughts on what you think the outcomes of this case should be. And let me start by saying what I think it should be, which is that if I'm the parties, I don't want to go anywhere near a trial on this. Sathya, you were talking about whether some of these issues were reminiscent of a league lockout and atmospheric. And when Jodi was describing early on what this case was about, I mean, I was thinking, my thoughts were, wow, this sounds like what the WNBA is going through right now and trying to decide how to split revenue share, because the revenue for NASCAR, Jodi, correct me if I'm wrong, the revenue is the television rights. And there is something when you're dealing with NIL, when you're dealing with collective bargaining for athlete associations, there's a difference if I am on a jury. And Sathya, you've done more jury trials than probably most of our listeners, and you can correct me if I'm wrong, but when you have an individual, a kid with a hard luck story, or when you have these well-known individual WNBA players, there's a certain sympathy you have towards their feeling like we are building this league as individuals, we deserve a greater piece of the pie, versus a car, or like the value of this abstract thing that is associated with my car racing team, whose value I want to prop up. And I just feel like I don't want to risk my chances by taking this. I would rather try to settle this rather than see what a jury comes back with. But let me ask you both, what do you think the outcome should be of this case?
You've stumped us. No, what do I think? It's difficult that I can't say that I've reviewed enough of the evidence to say exactly what the outcome should be. But if I can twist the question a tiny bit, I wonder, and this is at a minimum a trial theme that I think the parties will need to confront and have undoubtedly vetted before mock juries. Much of the plaintiff's case here talks about this willful acquisition or maintenance of monopoly power through the exclusionary conduct that we've talked about. Essentially a story about how NASCAR has created a position in which it is the only premier stock car racing association league out there, right? And it has jealously guarded that position and done a series of things to keep that 100% market share. And so I wonder if the true goal here, right, the true source of injury behind closed doors contended, is the absence of competition in the form of other premier stock car racing leagues or venues, right? Or if what the teams really want here is the status quo, but on different commercial terms, that is perfectly content with, 100% market share for NASCAR, but nevertheless being able to obtain the charters on the terms that they're looking for. And I'll just submit that sensitivity, that possibility, or that possibility for jurors is something that I would want to overcome and workshop and think about in presentations.
What Sathya just described aligns with something that I've been thinking about, which is why don't those 15 teams just get together and form a competing stock car racing circuit? Right? Why don't they do what the barnstorming NFL teams did in the 1920s and get together and form a league? They don't necessarily need NASCAR. As I mentioned, while NASCAR does either own or control through exclusivity contracts about half the premier stock car racing tracks in the country, the other half, another 25 or 30, are out there ready to be utilized. And they could reform the entire league in the image that they prefer. They can establish new car specifications that allows a little more freedom of sourcing, that still maintains competitive integrity. NASCAR is just a family and a name, and they're nothing without the 15 teams. And maybe there isn't enough sort of alignment amongst the 15 teams as to what a separate independent new league would look like. But, what I was describing before as potentially a bug, that these independent 15 teams do not actually have an ownership share in NASCAR the way that the 30-member clubs of Major League Baseball collectively own Major League Baseball, that might also be a feature because they could walk away. Maybe not now that 13 of them have signed charters, but what stops them from simply walking away and forming their own competing circuit?
Well, it's interesting, Jodi, right? Because we have a real world example of that, which is professional golf. I mean, I don't know to what extent LIV is supposed to be a long-term competing league versus, Sathya, as you said, like a negotiating tactic for some revenue share. But we do have an example of where people have done that.
Exactly. Not that successfully, mostly because they changed the product too much, right? So what the 15 NASCAR teams would need to do is offer a similar version of stock car racing, and not, as in the LIV Golf situation, 54 holes of team golf versus 72 holes of truly competitive golf.
Well, LIV also has a cash spigot that maybe make it an unusual example to hold up there.
Well,
Jodi,
maybe thousands are willing to bankroll a new competing stock car racing league. That's what they need to do.
Jodi, I think you make a really compelling point, right? That this is the unusual situation in which the talent and of the teams, right, can take all of the product, except for perhaps NASCAR's intellectual property, and move it to another piece of asphalt with, cameras set up and some stands for fans to sit in, and put on, I would think, a very similar event. I don't purport to be some NASCAR aficionado, but that seems like a distinct possibility. And then with that, I was noting among the pleadings that NASCAR has made something like $25 billion in TV revenue over the course of the last 25 years. There is plenty of equity share to be had, right, if they are willing to negotiate with the teams to prevent this possibility. It seems like there's a lot of room, I think, for NASCAR to give up some of their control and power to teams here, while obviously still preserving the product. Like that, another challenge for them at trial, right? Some of these rule of reason arguments about pro-competitive justifications. It's hard to sort of give too much credence to this idea that all of these restrictions are for the good of competition, for the good of consumers, right? For the betterment of the product, for the stability of the product. It seems quite extreme.
What I'm hearing in what you just said is even a third alternative to my suggestion of forming a league, which is NASCAR could finally sell memberships in NASCAR and become more aligned with a traditional legacy sports league, where you are a member club of the league and you have an absolute right to participate in it. a closed league, American style, where you own equity in the league and you can sell that asset over, which the legacy leagues have appreciated in value exponentially in the last couple of decades. And so, not that NASCAR should give anything away. I think that might have been its mistake with the first charter in 2016, in which it literally simply gave them away. But what they should be doing, perhaps, is offering equity in the family business in exchange for some significant capital investment, but that would award the purchasers control over an asset that they can then transfer, sign, sell.
Yeah, in other words, the assurance is there for the investor would be franchise value as opposed to medallion style value.
Exactly. And then they would have more of a voice. I mean, the way that the legacy leagues govern themselves is through executive committees of boards of governors in which each member club has a vote and ultimately decides by a supermajority vote in most cases, league business strategy and operational decisions and who gets to be part of the league.
Well, it sure helps with harmony among the teams and the league, even if it doesn't afford you antitrust protections downstream, right?
We'd like to end our episodes with a few takeaways for practitioners. Jodi, Sathya, we've covered a broad range of issues on this fascinating antitrust lawsuit, but what do you think are some key takeaways here for practitioners? Jodi, let's start with you.
Well, the key takeaway is that this case needs to settle before going to a jury trial. And that's what both parties are trying to do as we are recording this podcast. But also that NASCAR got ahead of itself with its counterclaims. And it's all, too clever pleading, I think, tripped it up in being able to contest some of the essential elements of the plaintiff's antitrust claim. And it's going to pay for that if it does go through to a jury.
Sathya, what do you want to leave our listeners with?
Well, I would say certainly be careful in your litigation strategy surrounding counterclaims and any concessions you might make along the way. I also see in this case some instructive lessons about overreach, right? Fighting relevant market and monopoly power in that relevant market where the evidence just doesn't support it, right? I think there is lessons that I try to learn over the course of a litigation in front of a judge, right? About how we can maintain credibility with the arguments that our clients are sometimes compelling us to make, right? And I see that in the Section 1 claims advanced by the defendants here and some of the hard-fought pieces around monopoly power in relevant markets.
Well, Professor Jodi Balsam, Sathya Gosselin, thank you for this terrific discussion of a clash between two of the biggest names in sports and one of the nation's biggest sports. To our listeners, be sure to subscribe on your podcast platform of choice, and we'll see you next time on Trust and Trade.